question this way. What does that do to section 47(1)(e)? Because section 47(1)(e) does refer to an appeal. In other words, a conviction must be a conviction which has been subject to an appeal, a sentence that has been subject to an appeal, and the appeal was dismissed or the appeal was upheld and the sentence was reduced.
Yes, but we know. Sorry.
Go ahead, that's fine.
But we know here that issue of whether or not he had the right of appeal was debated, found against this. We also know that he, in fact, attempted to rescind, also raising the very issue of the appeal. And even on that decision, that was dismissed. Now we come back to section 47(1)(e). It's simple the way it applies. Of course, if there is an appeal, we must look at whether or not, and you remember that if you look at the section 47(1)(e), what it says is that you have to take into account the appeal. So go back to the actual words. Anyone who, after the sanction took effect, is convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct constituting the offence would have been an offence in the Republic. But no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. So what it simply does, it simply allows the period of a conviction for a person who has been convicted to appeal it. But it even says, or the time for that appeal has expired. It's clear that where there is no appeal as a matter of law, that period will not be applicable. So it applies where there is an appeal, it applies where there is no appeal. But where the Constitutional Court has decided, in this sentence, in this conviction, there will be no appeal. That provision, what all it does is, we are not going to implement it now because we're going to wait for your appeal. But there is no reason to wait for the appeal where the Constitutional Court says we are the final court and there's no appeal.
But is it a proper way of interpreting the statute where you interpret it according to what had happened in a particular case?
No.
Because, I mean, obviously people need to know where they stand in relation to the application of Section 47. They can't decide their case on it as well. In this situation, this is how the section must be interpreted. But if this situation applies, it must be interpreted differently. Surely that's not the correct way of interpreting the statute.
No, but my Lord, what we submit here is that if you took the view that the judgment of the Constitutional Court on contempt does not apply, so Section 47(1)(e) doesn't apply to it because there is no appeal. If you did that, you would in fact be rewriting the Constitution, which is actually a worse position to be in. What we are asking the court to do is to give effect to the words of the section. It's clear that where there is an appeal, the section does not come into operation because we have to wait for that appeal period to either be brought or to lapse. But in circumstances where the highest court has made a determination and it has considered that appeal, the section still applies. The section is never excluded because the only way to get to that conclusion is by arguing that Section 47(1)(e) is excluded in the case of contempt of court criminal findings by the Constitutional Court. That we say is untenable.
Mr. Mukaiduri, would you say that this provision deals with several scenarios?
Yes.
Right? Yes. So the first scenario is that a person is sentenced.
Yes.
Right? Which is the scenario here. There was a sentence imposed.
Yes.
Following the imposition of a sentence, two things could happen. An appeal could be lodged.
Yes.
Right? Which is essentially a petition.
Yes.
By the convicted person.
Yes.
Seeking either a reduction or complete settlement or an interference with the sentence that is being imposed.
Yes.
Right? But then there could be a third scenario where it's uncertain. There's uncertainty regarding what's going to happen because the window for appealing is still open. Right? That's why the proviso further limits
Until the
time for an appeal has expired. So it deals with several scenarios.
Yes. Yes.
But given what has happened today, that there are no prospects of a further appeal, these scenarios are simply not applicable. They're irrelevant.
Yes, no, I would submit, my lady, that it's clear that in this particular case, the section applies. The section does not apply simply because the imposition of the
No,
sentence.
I'm with you. I'm putting
Yeah,
it.
okay, yeah.
I'm saying it's dealing with scenarios that are irrelevant
Yeah,
to the
yeah.
facts here.
Yes, to the facts.
Because he couldn't appeal.
Yes,
So the fact that there was no appeal to be determined.
Yes.
That's the second scenario. There was no, he had been sentenced.
Yes.
That's first scenario. Second scenario is that an appeal had to be determined
Yes.
if it was pending.
yes,
But that's inapplicable because he couldn't appeal.
yes. And the third
The
one is
third
expired.
scenario is that the period for appealing must not have expired.
Yes.
But that scenario also is irrelevant
Yeah,
here
yes.
because he simply did not appeal.
Yeah. And my lady, to add this, and I've said this to the court already, the appeal was debated, fully debated at the Constitutional Court. It was
But
debated.
even if it was not, just on a simple interpretation of the effect of the sentence imposed by the Constitutional Court, it's the ultimate sentence.
Yes.
Right? At this point, I'm not dealing with the intervention by the president.
Yeah, no, I'll deal with that now.
We're simply dealing with the sentence
Conviction.
as imposed
Yeah.
by the court. Yeah.
Yes, no, indeed.
So Mr. Nguma, my sister on my lap has got a question for you.
Fine, Mr. President.
Thank you, my lady, for actually pronouncing the full
Oh,
sentence.
sorry. I'm sorry. Yeah, sorry. Yeah.
No, it's fine. We passed that point and I don't want to take us back. You can proceed.
Okay.
Or the point you had a question on.
Yeah.
All right, thank you. All right, so I think we can leave the point at Justice Modiba's summary. So where we are right now is under Section 47(1)(e), he has been convicted of an offense. The fact that there is no appeal is irrelevant. The section cannot be written out of the Constitution simply because there was no appeal. What that leaves us then is the sentence part. Now, the way we understand the argument to be is that the sentence that Mr. Zuma was actually imposed with was 3 months because there was the remission of sentence. Now, the problem with why that is wrong is actually the premise. Now, I just want to go back to how Mr. Bofo raised this. So his argument, the way he frames the argument, is to say, well, in order for us to look at this issue of the sentence, is we must look at the ultimate sentence. He calls it the ultimate sentence. He says Section 47(1)(e) is about the ultimate sentence. And he says the reason why it is about the ultimate sentence is because of that appeal provision. So that's why it becomes secular. But that is not the case. Section 47(1)(e) is about the sentence that has been imposed by a court. If it is overturned by a court, so be it. The distinction is that it must be imposed by a judge. The president has no power to impose a sentence. Let's go back to the section. Anyone who, after the section took effect, is convicted of an offense and sentenced to more than 12 months in prison. So that's the first issue. When you look at the sentence imposed by the judges at the Constitutional Court, was that a sentence of more than 12 months imprisonment or not? We must not conflate this with these two judgments. And I've actually read these judgments, Smith and Moshefo. We must not conflate this with the period actually served, the date of release, which is what the remission did. The remission never changed the sentence. It never said you are no longer sentenced to 15 months. You are now sentenced to 3 months. It simply determined the period of the release. And the executive is entitled to do that. The executive cannot say, the courts did not say you are sentenced to 15 months. The executive can say, we are forgiving you, and therefore you are released, you can go home. This is the central problem with the argument, which is based on the so-called ultimate sentence. The ultimate sentence is true, but only partially true. It's true only if the matter will be dealt with by the Supreme Court of Appeal or by the Constitutional Court, because it is the Supreme Court of Appeal and the Constitutional Court that have the ultimate power to sentence. And that is what the section is about. The fact that the president says, I don't want to keep, I think it was this case of Mosheho, I don't want to keep sick people in prison, or I don't want to keep old people in prison, because I have the power to do so under Section 84 of the Constitution. In other words, the power to forgive, I've got that power. Does not mean that you can now go back and rewrite the sentence imposed. When you look at Section 47(1)(e), that section is about what was the sentence imposed by the court. That's textual. But purposively as well, it works. Why do we have Section 47(1)(e) of the Constitution? Why? The reason we have it is because it is a legislative determination that certain convictions and certain offenses would preclude a person from exercising their rights to come to Parliament. And the reason why they put it at 12 months is because it is a signal of the seriousness, not only of the conviction, but of the offense. And the reason they also make it clear that there should be no option of a fine, it's because what the constitutional drafters are trying to tell us is that serious law breakers should not be lawmakers. That's the purpose behind Section 47(1)(e) of the Constitution. Once you take an executive decision by the president, and you use that executive decision by the president to change, because the argument is as crude as that. It says, just change it from 12 months to 3 months, when there is in fact not even a decision by the president to change it from 12 months to 3 months. The president is simply saying, get out of prison, because the prisons are too full. But the sentence that the Section 47(1)(e) focuses on is, did the judges think this was a serious enough offense to take you to prison without a fine for more than 12 months? Once the judges have made that determination, then you are precluded by Section 47(1)(e) from becoming a lawmaker, because you are a serious and a serial lawbreaker. And we have to confront this problem and not try to tiptoe and make excuses for this particular appellant. So we say that, number one, the president has no power to change the sentence. He did not even purport to change the sentence. What he did do, he did not say Mr. Zuma is no longer sentenced to 15 months, but is sentenced to 3 months. He has the power to affect the period of release, not as the period actually served. And you'll see this clearly from these cases of Smith and Mosheho that have been referred to usefully by our learned friends. It's about releasing them. We say that, number two, you are also going to interfere with the purpose behind Section 47(1)(e), which is people in Mr. Zuma's position should not be in Parliament. It's as simple as that.
Sorry, Mr. Murago. I just want to make sure that I follow you correctly.
Yes.
As a result of a remission.
As a result
of a remission.
Yes.
The sentence. Where do we stand now? What is it? Does the remainder of the 15-year period still stands? Or has the release affected that?
No, he clearly has been released, but that has nothing to do with Section 47(1)(e). He clearly has been released. This court is not dealing with the remission. This court is dealing with what does Section 47(1)(e) apply to. And that is where there is confusion. We end up talking about the implications of the remission, but it's a completely irrelevant topic to what this court has to apply. This court has to answer the question, did the Electoral Commission correctly apply Section 47(1)(e) or not? The only portion of Section 47(1)(e) that applies to this debate, because we've closed the conviction debate to this debate, is what was the sentence imposed by the judges? And once the answer to that question is whether the judges imposed 15 months, You ask another question, did they give the option of a fine? Well, the answer to that is no, they didn't. The fact that the president came along and decided to forgive not just Mr. Zuma, many other prisoners, is irrelevant to the question of what sentence was imposed by the judges.
And your answer is that the sentence 15 years still stands.
No, the sentence,
15 months.
no, the sentence that was imposed by the judges for purpose of section 47(1)(e) applies, because that's what you have to apply your mind to. You are not sitting here as another correctional services board. What you are sitting here as is the electoral court to determine the question of eligibility. It's already prescribed in the constitution.
Mr. Mugandobi,
Yes,
let's look at the purpose of a sentence.
purpose of a sentence.
Yes, the purpose of a sentence that is imposed by the court upon conviction.
Yes.
Retribution, it's punishment,
Yes.
it's prevention.
Yes.
Right. So you are saying he is eligible to,
It's not eligible.
he's no longer illegal.
Oh, so eligible.
So he's disqualified
It's disqualified. Yes.
from
Yes.
National Assembly membership
Yes.
because a sentence of 12 months
More than 12
More
months
than
without
12
option.
months.
Yes.
without the option of a fine
Was imposed by the courts.
Right. And then the president exercising his powers in terms of section 84(1)(j decides, no, the court had said you will be, you are sentenced to 15 months, right? But then he decides that, no, you will not spend,
Not serve. Yeah.
you will not serve 15 months. You will only serve 3.
Well, I mean, that's also another problem. He never actually made that decision. It's just
The
a
effect.
calculation that they
Yeah,
made.
the calculation that had to be made. So he only served, because of the remission, he only served 3 months. The sentence that was imposed by the Constitutional Court, you are saying that determines whether he's hit by
It's
section
47.
47. But doesn't that section become academic? Because I want to, let's draw a distinction between a parole, right? A person who's paroled and a person whose sentence is remitted. So if a person is released on parole, that person effectively is not free. You see, Mr. Zuma was paroled on medical grounds, right? So, if the remission did not happen and he remained out of prison on the basis of the medical parole, he would remain an imprisoned. He would remain a person who's under the authority of the corrections department because he's still under punishment. You know, he's still sentenced, right? But what happened after he was remitted is completely different. The corrections department no longer had any authority over him because he was no longer under punishment. He was no longer a sentenced person. That sentence had simply fallen away.
That is what we argue against. We say to the court that the section 47(1)(e) focuses on the sentence that was imposed by the judges because it is the judges that, through their sentencing, reflect on the seriousness of the conduct of the prisoner. The fact that the president comes at a later stage to exercise his own powers to release a prisoner, to decide, for instance, people should not be in jail during COVID, which is why Smith and Buhasha. That fact does not affect the sentence that section 47(1)(e) focuses, because it says convicted and sentenced. What was Mr. Zuma convicted for? A crime. What was the sentence for? A crime. Was the sentence for 12 months? Yes. Option of a fine? No. So that section operates 47(1)(e). It is not disabled from its operation by a subsequent act of the executive. If you did that, we say you would ultimately undermine the purpose behind Section 47(1)(e), and we have posited the purpose behind Section 41(e), which stands in contrast with what my learned friend tries to argue, because my learned friend's framing of the case is Section 19 of the Constitution. But Section 19 of the Section 47 is also in the Constitution. So Section 19 applies to those persons who are not disqualified. And once you are disqualified, you cannot say that I have a Section 19 right, because that means you are making the Constitution internally contradictory. And that is what I'm afraid will happen if you upheld the argument that somehow the Constitutional Court determination became illusory. It evaporated. It never evaporated. It still remains. That was the sentence imposed, and that is why he's excluded by it.
Doesn't the remission of the sentence render the order of the Constitutional Court academic?
But we say no, it doesn't, because if you are to ask yourself, for purposes of Section 47(1)(e), what was the sentence of the Constitutional Court? What is the answer to that question? We say the answer to that question is clear. It is never rendered academic by a mere act of the president to forgive people that are in prison. It's an impossible legal position.
What is the issue?
My admission.
The original sentence imposed by the court.
When you are dealing with Section 47(1)(e), because Section 47(1)(e), that's why we say you've got to keep your eyes on the ball, because that section is about what was the sentence imposed.
So remission will not have the expansion.
No, it's not. It's not about, because there was never any sentence imposed by the president. There was only one sentence that was imposed by the Constitutional Court. And we say when you actually read that together with the purpose behind Section 47(1)(e), it makes total sense, because it's about the legislative choice that certain people that the judges have decided are serious offenders should not hold political office.
When he addressed us, Mr. Mpofu submitted that effectively Section 47 limits the rights in Section 19.
But it's,
Okay, wait.
sorry, madam.
That was his submission, and he reminded us that when there's any provision that clashes with the rights that are set out in the Constitution, an interpretation that promotes entrenched rights has to be preferred.
No, madam,
I'd like you to respond to
no,
that.
it's a fundamentally misguided proposition. The Constitution cannot be in contradiction with which is the other, right? The provisions of the Constitution should be given effect harmoniously and simultaneously. A Section 36 limitation applies to a law of general application. It doesn't apply to the Constitution itself. So the section we are dealing with here is a section in the Constitution. In other words, Section 19 applies to people who are not disqualified. And if they are disqualified by the Constitution itself, they don't have Section 19 rights. It's actually a fundamentally misguided proposition that is actually bankrupt on the constitutional jurisprudence, because it presupposes that you can have a scenario in which one section of the Constitution limits another section of the Constitution. There is no such thing. The two sections in the Constitution have to be read harmoniously together. The old Constitutional Court judgment of 2002, UDM, makes this very same point, that you cannot have two clauses in the Constitution conflicting with each other.
Just give me the year again.
It's 2002, it's the United Democratic Movement. That was the case of whether or not individuals who joined political parties could switch political parties in midstream. And there were clauses in the Constitution that were cited, I think, from the rule of law conflicting with the freedom of political choice and then political rights of political parties. And the Constitutional Court, in a unanimous judgment, says it is a legal nonsense that one section of the Constitution can limit another section of the Constitution. The two stand to be given effect harmoniously and simultaneously. And the only way to do that here is that Section 19 applies to those that are not excluded. Those that are excluded do not have the rights, because it's the same Constitution that says you are excluded if you are in this category. So I'm afraid it's actually a fundamentally misguided proposition.
Well, Mr. Nwako, let me see if I understand your argument. The argument is essentially is based on the separation of power, and it is as follows.
Yes,
Judges and courts
yes,
convict people and impose sentences on convicted persons. And it's only judges and courts that can change the conviction and sentence. The executive doesn't have power to change the conviction and sentence.
well, I mean, you could theoretically, I mean, there are instances where the president just says, from now on, I will not regard you as, well, they cannot change the fact that you're convicted.
I can see that, you know what I'm trying to get at, yeah.
Yeah,
Proceed.
yeah, so now, what they can never do, I mean, think about, for instance, the case of McBride,
Yes,
where there's a defamation case where someone says, you've defamed me because you called me nigger. The Constitutional Court says you can never take effect. You see, you can decide that I am actually going to forgive, but the fact that there was a conviction, the fact that there was an imposition of the sentence can never be changed. The only way that can ever be changed legally is by another judge. So what the executive does never changes the fact of the conviction. It never changes the fact of the sentence that was imposed. What section 47(1)(e) is about is asking this prior question. What was the sentence? What was the conviction? Was it for an offense? And what was the sentence? Was it 12 months or more?
sorry, but that argument, Mr. Nwako, doesn't undermine the purpose of Section 84 of the Constitution, which grants the president powers to relieve sentences.
Not at all.
Because I think that
Sorry, madam.
there must be a harmonious way to read Section 47 and the powers that are vested in the president to pardon, to relieve sentences. So you can't just read them in isolation.
No,
There must be a way.
We accept that entirely. But what we submit to the court, it's clear that it's an important part of the argument. We accept that the Section 47 and Section 84 must be read harmoniously. Section 84 is not undermined by an argument that Mr. Zuma is excluded by operation of the Constitution. Why? Because the purpose of the Section 84 was so that he could be released from prison. He was, in fact, released from prison. The consequence was that, as a matter of fact, he served 3 months and not the 15 months that the Constitutional Court said he should serve. But the question is, as a fact, what sentence was imposed by the Constitutional Court? And that is,
But Simon, that argument seems to put form above substance, because in substance, when a remission is granted, that has got an effect on the ultimate, well, let me not use Mr. Bofu's phrase, but that has got an effect at the end of the day on the sentence which a person served.
yeah, on the, no, I accept that.
Yes.
It has an effect on the period that is served. It has no effect on what sentence was imposed. And Section 47(1)(e) is about that question, because it is about our own society view on, which is collectively expressed through the Constitution. It is about the view of the Constitution, about whether or not certain people in certain categories should be allowed to stand for public office. That does not infringe on any right whatsoever, because it's a qualification criteria. Before you can have the right, you must be qualified.
Okay, I hear you.
Mr. Nkaitori, had the president pardoned Mr. Zuma and not simply remitted his sentence, would it make any difference to this argument? Would he still be a convicted
Yes, no,
person because the court said so?
that's excellent. This is really an excellent question, because it sharpens the focus of the debate. Because If I'm right in my submission, which is that section 47(1)(e) is about the judicial determination of conviction and sentence, it doesn't matter. Take, for instance, the case of McBride. The Constitutional Court makes it absolutely clear. The fact that you were convicted and sentenced never changes. And if the Constitution in section 47(1)(e) is about that fact, it applies to Mr. Zuma with a pardon, it applies to Mr. Zuma with a remission of sentence, it applies to him with a parole. So the problem we have here is that we are conflating concepts that belong to different species of the law. If we are dealing with constitutional law and who is qualified to stand for office or not, the Constitution answers that question. Now we cannot convert that and change it so that we can accommodate Mr. Zuma. He is one of those people that are precluded by the Constitution. That fact will never change. Thank you. My learned friend will speak on the bias point. I just want to check here if there's anything. Oh yes, there's one more point to the question Justice Modiba you have raised, which is what is then the benefit, the constitutional benefit, not general benefit. What is then the benefit of the remission? It's actually here as well, which is at section 47(1)(e). If you look at the last sentence of that section, a disqualification under this paragraph ends 5 years after the sentence has been completed, which means we're dealing with two different things. The one is the sentence that was imposed, but the second one is the sentence that was served. So he will benefit from it. 5 years from the 3 months that he served in prison. So it is not as if that pardon or remission never has a constitutional benefit. It has a constitutional benefit in the sense that at 5 years after he has finished being in prison, physically being in prison, you calculate 5 years from there, then he is qualified. Right now, he is not qualified either under the first part of section 47(1)(e) or the last sentence, which is the lifting of the disqualification. The lifting of the disqualification is about the actual completion, but that first imposition is about the judicial act of conviction and imposing a sentence. So, and that framing of the Constitution is actually perfectly consistent with the rest of the Constitution. And it has nothing to do with section 84, because he will one day benefit from that, but it's premature now. He's not qualified now to be a candidate. It's as simple as that. He's not qualified today to be a candidate. Thank you, Justices. Could I ask for permission to leave if there are no other questions directed at the arguments I have made?
So sorry, before you conclude, I just want to sum up your point that you made in relation to the last sentence in section 47(1). So you are saying, since the court imposed a sentence of 15 months, that imposition is what this court should work with, not the effect of the remission.
Yes.
And he will only qualify for National Assembly membership in terms of section 47. 5 years after that sentence has been completed.
Yes, which now means, because look at the time.
Wait. And my question to you is, when was the sentence completed?
Yes.
Because remember, and I invited you to explore the purpose of the sentence, right? And that consideration becomes relevant in determining when was the sentence completed.
So that's why I say that once you look at the last sentence to section 47(1)(e), it's completed. When you look at the first line, it's convicted and sentenced.
Yes.
So it's clear here that the intention is to focus on the actual period set. So if he leaves prison, it's the period set, which is you go to Bohoshi, and then 5 years from that period, because we cannot say, well, he has completed it when he is in fact out of prison. So we submitted that there is a possibility, if you look at that, to say the period was in fact completed when he left prison physically. But what you can never change is what was the sentence that was imposed on him.
So what sentence was completed, Mr. Mugabe? What is the sentence that was completed? Because we're trying to determine the date. What is the sentence that was completed?
No, Mr. Zuma, first, he did not complete his sentence. We know that as a fact. So he never completed his sentence.
Why?
Because he was released initially on medical parole, which was declared to be unconstitutional, and secondly, he was released on as part and parcel of a special remission. So he never completed the sentence.
But isn't the effect of the remission that when he reported back to Estrogen
Yes.
prison, and he was met with the news that the president has limited his sentence. What that meant is that he had completed serving his sentence.
Well,
Right, so that's the date.
Yeah.
He had completed serving his sentence. Why must we ignore the period that he served? Because that was the sentence. The period he served is the sentence.
no, maybe that is just incorrect as a matter of fact and as a matter of law. The period that was imposed on Mr. Zuma is 15 months. It is not 3 months. The fact that he subsequently serves, and we're not asking this court to further punish Mr. Zuma, we're simply asking the court to make a declaration that the IEC was right when it found that he was excluded by virtue of Section 47.
Okay, please answer this simple question.
Yes.
The last sentence reads, a disqualification under this paragraph ends 5 years after the sentence has been completed.
Yes.
In this scenario, in this case, what is the date?
But what we know here on this fact is that Mr. Zuma, as a fact, was released from prison.
Yeah.
So, which means whatever the courts decided would be the correct sentence, which is the first part of the section, was interrupted by presidential decision. So, which meant that he left prison. But that is irrelevant to the point I'm making to the court, which is Section 47(1)(e), current position that Mr. Zuma was excluded because the judges had imposed a 15-month sentence. You cannot change that by simply saying that the president effectively imposed a different sentence.
Please answer a very quick story. Sorry, I'm still. Please answer. Okay. Answer a very simple question.
Yes.
If the